He felt that they had a duty to come up with answers that have been long overdue and to try to close the case once and for all. Everyone feels that a great injustice has been done to the democratic process and that there's been a whitewash, a cover-up, and that things have been swept under the rug. A great deal of time has passed since the girl died, and it's time the public found out what happened. Hello and welcome back to my channel. And if you're new, then welcome. I hope to earn your subscription. Also, if you're new, maybe you should go back to the back of the series. If you're this interested in Chappaquiddick, you do not want to miss this book. It has been fantastic. This is probably the second to last episode, but we are starting today with chapter 50. And what we have done up to this point is gotten through all of the accident, all of the evidence gathering, all of the will they, won't they, of whether or not they're going to investigate or bring a charge against Ted Kennedy. Finally, they landed on the inquest, and they struggled over whether or not there were constitutional rights protected in that. They finally figured that out, and Ted Kennedy has given his statement. So that's where we find ourselves right now at chapter 50. Here's what happened after Senator Kennedy testified. A summary of Senator Kennedy's testimony was dictated by Clark and Hannafy, the lawyers who were present. A recital, by necessity foreshortened, because how much could they actually take down in longhand of what he said in the courtroom, Donegan said later. It was no substitute for a transcript. I just want to point out to you that they are giving this full accounting of Ted's testimony to Joe Donegan. Joe Donegan is the Boiler Room Girls' lawyer, the one that Ted Kennedy retained for both the Boiler Room Girls and the men who were at the party, other than himself, Joey Gargan, and Paul Markham. Those two men, because they had greater access to what happened after the accident, had retained their own lawyers. Everybody else had this one lawyer named Joe Donegan, and they are literally saying, here's everything we can think of that Ted Kennedy said, try to get it in the order that he got it. They're making a script of what happened. Donegan did not know why such a record was being made, but surrounded by lawyers, Donegan wasn't concerned about the legality of his assignment. I guess because they were all protected by client privilege. Is that what's happening? So you can do anything illegal you want as long as you're surrounded by lawyers and doing it in service of your client, arguably? Is that what's being implied here? I think it is. Maybe I'm not understanding that right. He says, the only testimony they were interested in getting was the people that were at the party. The average take was a couple of pages, if that much. It didn't take me very long. It was just an outline of their testimony, very meager, really. But it was sufficient to provide a working script, to keep succeeding witnesses on track with the senator's testimony and prevent anything contrary to it from getting into the inquest record. They are so shifty, y'all. Can you believe that they did that? If you don't understand what I just read, let me put it to you over again, because it took me a minute to read and realize what they were doing. They wrote down as much as they could remember of exactly what Ted Kennedy said. And the person doing it is the lawyer for all these other people who are going to testify to what he did. So this becomes their script. This becomes their pattern that they can look over. The instructions from the judge were, you're not allowed to talk to any other witness. What he did not say is, your lawyers can't write down what you said and share everything that's written down with the other witnesses. I don't know. I guess he could say that. I guess he could say, no written materials, nothing shared, absolutely zero barrier between the two. But how are you going to do that when one lawyer represents 6 girls and 3 men who were all at the party? And also, I want to point out, why would you do this unless you have things to hide? Unless you're concerned that there could be discrepancies in the testimony that would point to someone's guilt, why would you have to do this? Final thing I'll say is that this, I think, was what Edmund Denise, the DA, was trying to avoid. He actually wanted Ted to testify last. Well, no matter how hard the Kennedy legal team tried, risks remained. Ray LaRosa came the closest to placing the credibility of the senator's testimony in serious jeopardy. LaRosa testified that he had not seen the senator leave the party with Mary Jo. After Gargan and Markham left the party, LaRosa had gone for a walk with Nance and Mary Ellen Lyons. Remember, we heard a description of this from Huck Look, that he ran into this group, we can assume. Here's how it's described from Ray LaRosa's testimony that he's giving at the inquest that we've never heard before. A car coming from the direction of the ferry had stopped. A man asked whether we needed help or something, and one of the girls made some kind of statement. I think she said, "Shove off," or something of that nature, LaRosa said. Yeah, well, interestingly too, because it was this is the patrol car. So there's a patrol car with a guy in a badge and a uniform, and he just says, a car coming from the direction of the ferry. A man asked whether we needed help or something. So maybe he was just totally toast, which is likely, that maybe he just was paying attention to the girl and not the car. Before that occurrence, however, another car had come along, heading toward the ferry in the same direction LaRosa was walking, he said. And I held my hands out to kind of protect the two girls. The car slowed down and didn't stop and just continued on its way. That LaRosa had seen another car between the cottage and the intersection at the same time one was observed there by Huck Look was a revelation that could explode the senator's testimony about the time the accident had taken place. So that is exactly what Huck Look described. I'm going to put a map up of this intersection situation while I do this little demonstration with power banks. Got my little tiny power bank and a big one that I use. So this one is Ted Kennedy, big black car. This one is the patrol car. So let's imagine this. And it's exactly what Huck Look describes with Ray LaRosa's testimony. So Ray says they're coming from the cottage. So we're putting ourselves on that road. So this car passes them, right? And in the meantime, Huck looks over here. He's coming from the ferry at some point. So this car is going this direction, goes in between them and Chappaquiddick, or in between them and the ferry, goes this way. And according to Huck Look's testimony, he watched that car pull into the cemetery road. And then when he got close, they back out and head right down Dyke Road. He continues on the main road, which is where he encountered the three. So we have the exact situation Huck Look's describing. We have Ray LaRosa confirming that Huck Look was right, that he would have seen a second car and that, that he encountered that group of three. Remember, they were doing the conga line, is how he described it. There's three people, one man, two ladies, is how he described it, doing the conga out in the middle of the road. So my perception is from everything that's happened, everybody is said is basically toast, except for Joey Gargan. Joey Gargan was one of the few that was sober. There might have been one other person. But everybody else, it says, is multiple drinks in. And Ray LaRosa is out there with the conga line, and he doesn't even apparently remember, or he doesn't want to say on testimony. He just says, some car, some guy. Okay. But the bomb that LaRosa dropped on the inquest didn't detonate. Neither Denise nor Boyle pursued the subject of the other car. Wow. A young Boston attorney and Kennedy campaign aide, Charles Tretter, who was one of the party attendees, told the inquest he had not seen Senator and Mary Jo leave the party, but became aware of their absence around 11:30 when he went for the first of two walks he took with Rosemary Keogh. Something going on romantically between Rosemary Keogh and this Charles Tretter figure. They were the ones who theoretically remember the party was such a dud that they had gone over the ferry, just the two of them together, to get a radio on the main island, and then come back to Chappaquiddick later with that radio. And supposedly that is why Rosemary Keogh's bag was in the footwell of the passenger seat in the accident vehicle. Well, he says this is the first of two walks he takes with Rosemary Keogh that night. He says, I had to go by where two cars were parked, but there was only one car, the white Valiant. So he sees that the black other vehicle was missing. Tretter had walked into a time trap. Had the accident occurred when Senator Kennedy said it did, and had he returned to the cottage at 12:15, as he testified, to fetch Gargan and Markham, Kennedy would have encountered Treader and Keogh on their walk toward the intersection. Kennedy later acknowledged it was very unlikely he could have missed anyone on so narrow a road. So they did not see one another, and yet Charles Treader is saying, we went out for this long walk, and we never saw a vehicle. So that actually lends credence to it having been much later, that not 11:15, but Huck Look saw him around 12:30, and at some point between 12, really he saw him around 12:40 or 12:45, because he got off from the party at 12:30, came across the ferry, got onto the road, went straight onto the road. So we're talking 12:40, 12:45. At some point at that point is when he goes across. So if Senator Kennedy had come back by 12:15, that wouldn't have allowed for any of this, and he would have encountered Treader and Keogh on the road, but they didn't. Treader resumed the witness stand the next day. He said he had not known about the accident until Saturday morning. It was clear from the testimony that Treader wasn't paying much attention to anything but Rosemary Keogh that weekend. So here we have it. Keogh stumbled badly when it was her time, finding it difficult to keep in mind the hour-and-a-half differential between the senator's version of the accident and that of Huck Look. Keogh thought it was 12:15 or 12:30 when she went for her first walk with Treader. Returning to the cottage some 45 minutes later, she found the place empty, so that would be around 1 a.m., except for Jack Crimmins asleep in the bedroom. So Keogh resumed her promenades with Treader for another hour and a half. Keogh had seen the senator and Mary Jo leave the party at 11:20, she said, having looked at Susan Tannenbaum's watch. But despite her avowal in August to answer all questions fully and cooperatively, she had little else to say. As far as I'm concerned, she said later, there's only one person who really knows what happened from the beginning of the incident to the end, and that's Edward Kennedy. Keogh and Treader were suffering a problem unique to Kennedy witnesses. Having gone to the Shiretown Inn to borrow a radio, danced together at the party, disappeared for 2 midnight walks lasting over 2 hours, and slept side by side on the living room floor, it was clear a flirtation had blossomed during the weekend. Treader's wife was reportedly furious at the episode of dalliance. In preparing Treader's testimony, it was another lawyer's idea to just keep him walking in order to save his marriage. Having to account for his own activities didn't leave Treader much time to even consider verifying Kennedy's story or contribute significantly to the transcript. So they're so deep in trying to cover themselves and cover up what they had been doing that they hardly give any thought. They're just like, yeah, I didn't know anything about Kennedy. But the transcript was not only serving as the memory aid for the witnesses. This is so fascinating, you guys. It also is a means of exerting control, which I hadn't thought about. I get this far into the chapter when I was reading it, and I just thought, wait, what in the world? As witnesses go into the courtroom, they already know that everything they say in the courtroom is going to be put down in private by their own lawyers onto this private record. So there's a built-in function of forcing you to say what will match up, because you already know everyone who attended the party, plus probably Ted Kennedy and all the lawyers, are going to see precisely what you testified to. This seemed sure to inhibit any spontaneous deviation from the script on the witness stand. It's brilliant. It's terrifying, and it's brilliant. So tightly was the control being exercised that the Boiler Room girls excused from testifying at the second day's inquest session were not allowed to leave the courthouse unsupervised. As the second day of the inquest progressed, attention centered on Joey Gargan and Paul Markham, the lawyer friends, Newsweek observed, who, though not suffering from shock, had joined Kennedy in his long post-accident silence. So they're catching heat. In many ways, Gargan and Markham had more to clarify than Senator Kennedy, since they were presumably lucid. if Kennedy was dazed and, totally in a place of confusion and shock after his accident, which multiple behaviors after the accident show that he was not entirely in shock. He had a really normal kind of conversation with the desk clerk. He gets completely clean clothes on, and then the next morning he's just talking and chatting, and nobody could have told there was anything awry. So multiple things indicate that he was not in some post-accident confusion for 9 hours where he just didn't know, and then according to what he said in the TV broadcast, kind of came to himself and suddenly realized that he needed to go and report, and went and reported right away. None of that is true. These two guys don't have the option of saying, well, I was kind of in a mental state of confusion. They're both perfectly in their right mind. Now, we know Markham had apparently been nursing some sort of leg injury, I believe. He had been using alcohol not only for the fun of it, but to kind of quell his own pain in his leg. And so he was super drunk, super useless, and Joey Gargan was the one who was sober. But even with the drunkenness of Markham, Joey Gargan should not have been dazed at all. And so they would not only be asked about Kennedy's activities, but their own, particularly why neither had summoned help or reported the accident to police. As the only witnesses who could corroborate Kennedy's post-accident behavior, they could be expected to be the target of Denise's most probing questions. Gargan said he wasn't worried. He said, I was simply going to tell what I saw and what I did and what I heard. He did far better than that. This is absurd. So you know how everybody sees him as the bag carrier, as the guy who kind of takes care of the details for the Kennedys, does all the grunt work, sets up hotels, that kind of thing. They don't see him as his cousin. They don't see him as the guy who gets him out of scrapes. They see him as the guy who, like, when you need to check travel plans, check with Joey. He's like the campaign guy who oversees that. Building on that image, he played it for all it was worth on the witness stand. He begins throwing out a torrent of irrelevant details, describing his role as a crew member during the regatta race. Things like having to hold on to the stay, forcing my back out in this position with the pole holding the spinnaker out. Bunch of nonsense that he knows they don't want to know about, but that's what he's talking about. He larded his testimony with culinary techniques that he had employed at the cookout. Chatty just like a neighbor exchanging recipes across a backyard fence. He said, I took out of the refrigerator what you would call frozen hors d'oeuvres, some of which have sausage and some of which had cheese. I turned the oven to about 450 degrees that take about 12 minutes to cook. After they were ready, I took them out and started to pass them around. So he is just filling his testimony with nonsense, which is really funny, actually. I mean, it's absurd, but it's a really funny move. Okay, fine. You want to know everything? I'll tell you everything. Denise later confessed he had been disarmed and amused in spite of himself and regaled his staff with Gargan's testimony. Yeah, remember, nobody else is seeing this, just the lawyers, the judge, and whoever is testifying, and then the DA, Denise. So he's watching all of this. But there's no audience other than the judge and the DA. Between working at the kitchen stove and the grill out, he said he hadn't noticed which guests at the party were drinking or how much. Kennedy left the party between 11:25 and 11:30, is what Joey Gargan says. I saw him go out the door of the cottage with Mary Jo Kopechne. Where he went from there, I don't know. Gargan assumed they were going to the ferry because of the conversation that had been had with Jack Crimmins. Remember when Jack Crimmins was like giving them all heck, trying to get them out of the house. He's like, get out, get out, get out, go. The ferry leaves at midnight. You got to get out of my house. He is angry. He is rude. He was drunk, and he did not want them staying there that night. I guess he wanted to be alone. Remember with the raccoons or whatever was scraping at the door and terrifying him? I guess he wanted to be alone. Mr. Crimmins was sometimes somewhat agitated by the fact that they weren't moving out of there. Crimmins had complained that it was 11:15 and we all ought to think about leaving because the last ferry left at 12. Gargan did not mention Crimmins urging him to get these douchebags out of here or his state of intoxication. He said the gist of the conversation was that Jack wanted everybody to go home. Gargan testified that he next saw Senator Kennedy in the back seat of the Valiant when Kennedy announced, "The car has gone off the bridge down by the beach, and Mary Jo is in it." Gargan drove just as fast as I could to see the accident scene. When attempts to rescue Mary Jo failed, I didn't think there was anything more could be done. The senator had been very emotional, very upset. He told me he was going down the dirt road, headed toward I don't know what. He suddenly saw the bridge in front of him, and that was it. He went right off into the water. Gargan couldn't testify to that dialogue word for word, but I do recall that the thrust of the conversation, and I was the one who said it, "We have got to make a report of the accident immediately." Before the senator did so, however, Gargan did suggest that he call David Burke to let the family know he was all right, and Burke Marshall, because Burke Marshall is the best lawyer I know. So David Burke is his administrative assistant. Burke Marshall is the lawyer. The senator told him to go back to the party. Don't upset the girls, don't get them involved, and then dove into the water. Gargan said he drove to the cottage, turned the car around, and returned to the landing. He decided the senator was going to report the accident. Following the senator's instructions, Gargan said nothing about the accident when he returned to the cottage at 2:15 a.m. Quick arithmetic would have revealed that Gargan's timing did not jibe with Senator Kennedy's. Had the rescue efforts taken approximately 45 minutes from the time that Kennedy had returned to the cottage to seek help, that would have placed him at the landing at 1 o'clock. Gargan had left more than an hour unaccounted for. So Gargan's timing of returning to the cottage around 2:15 actually fits with the 12:45-1 time frame of the car going off the bridge, not the 11:15, 11:30 time frame. Given the difficulty of tracking such vague testimony, Denise did not pick up on the time discrepancy. Denise did not ask if the senator had been in shock or what excuse Kennedy had offered the following morning when Gargan learned that the accident had not been reported. And I just want to say at this point, there is a prolific amount of incuriousness. There's so many questions not being asked that they have almost spilt more ink on the questions not asked than the ones that were asked. Despite the widely published speculation that Gargan had been asked to take the blame for the accident, Denise failed to ask if that was something that the senator had proposed. Gargan was prepared to say, yes, that was discussed, but not acted upon. But Denise spared him the necessity of even having to do that because he didn't ask the question. Well, if Markham couldn't match Gargan's performance, he did comport himself well on the witness stand. By Markham's best estimate, it was shortly after midnight that Kennedy returned to the cottage seeking help to rescue Mary Jo at Dyke Bridge. We were singularly unsuccessful trying to get into the car. The current was very, very strong, Markham said. The girl was apparently gone. We had to get help and report the accident. So this actually goes back to a previous question I had, which I went back and looked. It's on pages 105 and 106. But here's what he said. It sounds to me like Gargan is describing being in the car. You tell me. Gargan swam to the front of the car. Working himself down to the side, he found an opening he presumed to be a window and passed his body through, groping around to see if I could touch anything. To me, this is Gargan's confession that he actually felt Mary Jo's leg, knew she was dead, and therefore their actions make sense to me. I have to tell you, the longer I've sat with this, the more I feel that this is what's true. That whenever it happened, he actually did get into the car. Markham doesn't describe it. Gargan did back here for Leo Damore. So that's what we're hearing. He says, you had to operate by feel only. The current forced your eyes closed. The car was full of water. The current was running right through it. There was no air inside the car. There couldn't be. It was completely submerged. Gargan started losing his breath. He tried to get out and couldn't. He got stuck inside because in turning to feel around, I'd gotten jammed in. Instead of turning again calmly, I kind of pushed myself out fiercely. He felt something sharp rake his arms and chest as he passed out of the car. He came to the top of the water, gasping for air, and was flung backward by the current. Okay, so that description is what was given to us as Joey Gargan's description just to the author when he wrote that. And that would have been well after, that would have been in the 80s. So he's giving more information than he gave to the inquest of what we're reading now in today's selection. But what I want to propose to you is that this is actually what happened. And I actually think that he felt Mary Jo's leg. That's what I think. And that she was already dead. And so that's why the things ceased. That the rescue efforts stopped at that point because he felt the dead leg. I don't know for sure. I think the description of, things, but that's where I stand, and I'd love to hear your thoughts about that. Okay. Even the part of Markham's testimony here where he says, "We were singularly unsuccessful in trying to get into the car. The current was very, very strong. The girl was apparently gone. We had to get help and report the accident." I think that based on what we've read, that's probably what happened. As Fernandez understood Markham's testimony, the reason that you or Mr. Gargan did not seek assistance or notify the police was that you assumed Mr. Kennedy was going to do so when he arrived in Edgartown after the swim. That is what he told us, Markham said, truthfully. The two witnesses who, besides Kennedy, had the most explaining to do, had gotten cleanly away. Unlike Senator Kennedy, both had testified without knowing in advance what questions were to be asked. Gargan was shocked when he learned later about the meetings that Stephen Smith and Jack Miller had held with Bernie Flynn out of the DA's office. To him, that kind of overkill was people not only trying to protect Ted Kennedy, but the Kennedy image. They were going through an enormous effort and extent to do that, and in their enthusiasm, I'm afraid some people overreacted. So that's how he thinks about the situation where Bernie Flynn, the investigator, is going to Ted Kennedy's brother-in-law and his lawyer to give information all about the inquest. Chapter 50, Observations. Ted Kennedy's lawyers and the Boiler Room girl's lawyer are note-taking while they're in the courtroom so that they can go back and produce a working script so each subsequent witness can keep their testimony in line with the ones that have come before. This is also subtle pressure to watch their words because they know it'll be recorded on paper. Ray LaRosa mentions Huck Look and seems to verify the time frame. Treader and Keogh had a 2 to 2.5 hour walk. Gargan, in his testimony, labored over extremely minor details and filled up his testimony with random little bits of information. Gargan's times don't jibe with Kennedy's, but no one asks. And Markham testifies to the rescue attempt, to Ted Kennedy's emotions, and to Ted Kennedy's intent to report. Chapter 51. Taking his lead from Denise, Armand Fernandez was not as aggressive in his questioning of witnesses either. He failed to question the host about the party when Ross Richards took the witness stand. There had been a regatta race party. He doesn't ask about it. Instead, he confined his questioning of Richards to the events the morning after the accident. Richards had spent half an hour in Senator Kennedy's company on the deck of the Shiretown Inn talking about the previous day's race. He observed no injuries or anything out of the ordinary in his speech, appearance, or attitude. There wasn't a word mentioned about Chappaquiddick, he said. Markham and Gargan had appeared ruffled when they arrived. I would say they looked damp. Their hair hadn't been combed in some time. They might have been wet from the night's dew or fog or something. Richards denied telling a detective from the DA's office both men had been soaking wet. He said, "I did not say that, I'm sure." This to me feels more aggressive. Fernandez wanted to refresh Richards' recollection by reading from Lieutenant John Dunn's report of his interrogation, but Boyle would not allow it. Fernandez didn't question auto dealer Stan Moore because he had nothing to add. So Moore had been pondering how he was going to get around telling the inquest about all of the highballs that Ted Kennedy had enjoyed on the boat, but he was excused and asked no questions. So the decision not to put Moore on the stand had been made by Denise, Fernandez later said. Both Richards and Moore had refused to talk to police about the drinking. It was obvious they were protecting Ted Kennedy. There was no reason to believe they wouldn't do the same thing on the witness stand, and that's why Moore wasn't called. As the second day of the inquest neared an end, the first of the Boiler Room girls was called to testify. Other witnesses could follow the script without difficulty. Esther Newberg had to square hers with a number of interviews that she had granted the week after the accident. In those interviews, she had gone on the record as saying, quote, "No one specifically missed Senator Kennedy or Mary Jo Kopechne or noticed what time they left the party." She had described the group back at the time of these interviews as an informal group with no one keeping particular track of who was there or who wasn't at any given time. But the time element had become crucial to shoring up Kennedy's version of the accident. Now under oath, 5 months after the accident, Newberg suddenly remembered that Kennedy had left the party at 11:30. "I have a rather large watch that I wear all the time, and I looked at it," she said at the witness stand. "I saw him walk out of the screen door. Mrs. Kopechne was directly behind him." Mary Jo had appeared completely sober. Judge Boyle asks, "If I tell you that Mary Jo's blood had a content of 0.09 per 100% of alcohol, which by expert testimony would be somewhere between 5 or 6 drinks, would this change your testimony in any respect?" Mary Jo was not a drinker, Newberg said. 5 or 6 drinks would have been completely out of order with the way she lived her life. "I'm only telling you what a chemical analysis shows," Boyle said, "and the chemical analysis is practically irrefutable." "Then I'm the wrong person to be asked," Newberg said sharply, "because as far as I was concerned, she was completely sober." "And you saw her the time she left," Boyle said. "Exactly the time she left," she shot back. But Newberg didn't know where she was going. She overheard Gargan tell the Lyons sisters something to the effect that the senator swam across. Perhaps in my own mind, I then assumed that Mary Jo was back at the motel. Boyle wasn't buying it. "How did you believe Miss Kopechne got back to the motel?" "She had driven the black car back. They had left before midnight, so I knew they could make a ferry without any trouble." "She had driven, and he swam?" Boyle asked incredulously. "Nothing is said by her to you or anyone else as to where she is going. Now you make an assumption that she is going back to the motel?" Wow. Judge Boyle is suddenly curious. He's uncharacteristically going after someone and trying to find the truth, which is fascinating to watch. Almost nobody has any curiosity about any of this. And he's suddenly really going to town on her. Newberg assumed that Mary Jo was going into the front yard. Later, I had the assumption that it was a long day watching that race. She was exhausted, and the senator was probably driving her back to the motel so that she could get some rest. "Without her saying a single word to you or to anyone else at the party?" Boyle asked. "That's right," Newberg said. "At that time, you and the other girls are expecting to go back to your motel. Didn't somebody walk out to see 2 motor vehicles gone? Suddenly you're left without transportation on an island, and none of you girls said, 'What are we going to do? What is happening? This isn't the plan.' No questions of any kind are discussed among you?" I love that somebody's finally going after this, but unfortunately it's too late. I wish they would have done this from the start. "There was some concern about whether we could make the ferry," Newberg said. "After 1 o'clock, we realized we weren't going to go back that night. Something was said, 'We have to make the best of a bad situation and attempt to sleep.' We had no reason to be unduly alarmed." "You could think of no reason why 2 men should take leave of the last transportation available without saying a single word to you?" Boyle asked. "That didn't excite you at all?" "We all wondered where Mr. Gargan and Mr. Markham went," she said. "Nobody volunteered any information. Later, when Mr. Gargan said the senator swam across, it was almost as if we didn't need to know. He didn't seem to want to talk in detail about what happened. By that time, we couldn't get off the island anyway, and we assumed that Mary Jo was back in that hotel room." The most argumentative of witnesses, Newberg had won the sympathies of Armand Fernandez. It was obvious that Boyle had taken a dislike to her, he said. Dislike or not, Boyle had no intention of letting her off the hook. "Did you at any time have an interview or conversation with any reporters?" "The last time was the week of the accident, the day after the funeral. I was in the state of extreme duress." But Boyle wasn't referring to those interviews, but a report published in December. No, I'm sorry. I can see what you're reading from. That looks like one of the trash sheets, like the National Enquirer. I never talked to that reporter. I never talked to anyone after July. Since the Boiler Room group was lodged together, Boyle specifically ordered Newberg not to discuss any portion of your testimony with any of them. Newberg didn't have to worry about disobeying Boyle's instructions. Paul Redmond was doing it for her. If Boyle was going to question his other clients as searchingly as he had with Newberg, Redmond wanted them prepared. So he said, "Warnings about witnesses disclosing testimony be damned." Redmond was going to prepare his other clients. If Boyle wanted discussion among the young women at the party as to what was going on, Redmond was happy to supply it through the testimony of Mary Ellen and Nance Lyons. When Markham and Gargan had returned to the cottage around 2:30 to 2:45, they had been asked, "Where have you been? What is going on? What is happening?" They stated that they had gone with the senator to the ferry, and the ferry wasn't there. They said they couldn't find a boat, and the senator dove in and swam across, that Miss Kopechne had taken the car to the Katama shores. "Didn't you say to them, 'Well, how come Mary Jo takes the car and the senator swims?'" Boyle said. "Did you have some thoughts in your mind that this was most peculiar?" "No, not really," Mary Ellen Lyons answered. "We were just saying, where is everybody? The only thing we could think of was that a car was stuck in the sand." Mary Ellen had noticed Senator Kennedy and Mary Jo were not at the cottage around 11:15 or 11:30. Just after a while, they weren't there. Nance Lyons gave a similar testimony. She had seen them walking out the door. I would say it was 11:15. It hadn't registered that they were leaving the party permanently. Then an hour later, Ray LaRosa came in from outside and said in a rather loud voice, because people were talking, "Mr. Gargan, Mr. Markham, Senator Kennedy would like to see you." Susan Tannenbaum followed the Lyons sister to the stand. She had seen Mary Jo, but not Senator Kennedy, leave the party. "Were you surprised to find out, without your knowledge, that all the transportation had gone so that you couldn't get back to Edgartown?" "Yes, I was surprised," Tannenbaum said. "Was there not some discussion between you and your friends about it? No one said, 'Well, gee, this is unusual to leave us stranded here'?" "Not that I remember," Tannenbaum said. "You're not accustomed to being deserted in that fashion, are you?" Boyle said with obvious irony. Exasperated, he dismissed the witness. He said, "You may leave the courtroom and go, I assume, right to your friends." I mean, he rebukes them verbally, but does nothing legally. He sees what's going on, and yet he doesn't do anything to do anything any different, to bring justice or to bring clarity about what's happening. Susan Tannenbaum's testimony made the crucial time factor unanimous. Every Boiler Room girl had seen Senator Kennedy and Mary Jo leave the party between 11 and 11:30, a remarkable display of unanimity for those whose memories had lapsed about any other event at the party. But multiple endorsements had been required to support the senator's accident time and to overwhelm Huck Look's anticipated testimony by the sheer weight of numbers. That's the end of chapter 51. So here are our observations. Ross Richards gives no alcohol details. He walks back how wet Gargan and Markham were the morning after the accident. Esther Newberg has to square this testimony she's giving with the other witnesses and her own previous interviews. Boyle gets testy questioning Esther Newberg, but nothing comes of it. And the Lyons sisters and Susan Tannenbaum all saw Ted and Mary Jo leave between 11 and 11:30, and really they all recalled virtually nothing else about the party. Chapter 52. To corroborate Kennedy's version of the accident, witnesses had to know what they couldn't know, where the senator had gone after leaving the party. Esther Newberg conceded the real story is what went on in that car and what went on during the next 8 hours, and I have no knowledge of anything in that period. Neither did anybody else. But one man believed he did know something about the missing hours that no one else did. Taking the witness stand on Wednesday, the third day of the inquest, Huck Look repeated his testimony that he had given at the exhumation hearing in Wilkes-Barre. A dark car with an L7 license plate had passed in front of him at the intersection of Dyke and Chappaquiddick in the early morning hours of July 19th. Boyle wanted Look to be more specific than just a dark car. The vehicle, he said, was either black, deep blue, or dark green. Then you are unable to positively identify this car. No, I can't, Look said. Despite this challenge to Look's testimony, Boyle actually took steps to to corroborate it. He ordered the DA's office to they had not done this investigation, but he's telling them to do it, to go through the registry of motor vehicles to determine how many cars in Massachusetts had registration plates with L7 configurations. That should have been done a long time ago. Killen assigns Bernie Flynn the task. It was like 3:30 on Wednesday when I called the registry, Flynn recalled. But Flynn had no trouble receiving the very next morning a list of the L7 license plate owners. Only 8 of the 50 plates had been issued to operators of Oldsmobile-type vehicles. So he has it narrowed down to 8. Flynn called the automobile owners on the list and asked, was your car on Chappaquiddick on the night of July 18th? None had been. Flynn turned the results of his investigation over to Killen, and though the results seemed to prove conclusively that the car Huck saw had to be the one that Ted Kennedy was driving, Flynn later learned that this evidence was not used at the inquest. I don't know what the reason was, whether it came in too late or what, Flynn said. Boyle himself later revealed the attempt disclosed that it would not be feasible to do this since there would be no assurance that the end result would be helpful. He wasn't interested in knowing the findings. Weird. Again, we find whether this is the result of a fix or just mixed motives or people who try something and have good wishes and then somebody gets to them after the fact and says you're not going to include that information in the inquest. We don't know. But for whatever reason, he like a dog is like going after the information, and then all of a sudden it's like, I didn't think that would actually help, so I didn't include it in the inquest. So weird. Flynn's detective work was not the only registry evidence kept out of the record of the inquest. 3 register inspectors en route to the inquest on Thursday morning to testify were told they weren't needed. Also, the registry itself was not forthcoming in producing evidence. George Red Kennedy, that's the inspector, the vehicle inspector who was there on Chappaquiddick the morning of the accident, Kennedy's report of the accident had been kept out of the hands of the DA, and so when he's asked about it, Inspector Kennedy, the man who was there that morning, says his license was valid until February 1971. Not true. The actual fact was that it had not been present. They couldn't find it. He did not have one. He claimed to have a license, and they gave him one after the fact. With the report of the 2 license checks in hand, Fernandez was surprised that this witness was prepared to lie under oath. He gave Kennedy, Red Kennedy, it's kind of complicated because it's weird that the vehicle inspector would be Kennedy on a Kennedy case, but that's just the way it is. They're not related. That's the way it is, but confusing. He gave Kennedy another chance. Did they produce the license immediately? Realizing he had been caught in the lie, Kennedy changed his testimony. The license was produced, he said, at another date. His remaining testimony was equally questionable. Based on the measurement of the skid marks and his experience investigating more than 100 accidents, he was of the opinion that the accident car was traveling approximately 20 to 22 miles per hour, corroborating the senator's estimated rate of speed that he gave in his operator's report. That testimony comes to an end, but unfortunately, other testimonies are also going to be manhandled by the judge and the DA. Boyle says he is not concerned with the problem of survival in an immersed automobile, since there was no evidence that any air had remained in the car. Testimony would not be sought, nor allowed, concerning how long Mary Jo Kopechne might have lived in such a condition, as this would all be only conjecture and purely speculative. Well, I will say, because they did not do some of the classic medical examiner tests that were even common at the time, I believe they didn't do a temperature check. There were a few other simple tests that are apparently done commonplace by every medical examiner at that time that were not done on her body. And so they would not be able to prove how long she had been in rigor mortis or that sort of thing. So in this point, he is telling the truth. It would be conjecture and purely speculative, but that doesn't mean that it would be completely irrelevant. Nevertheless, Boyle said, whether additional assistance would have been of any material help in rescuing her had not been pursued, because, quote, such failure, even when shown, does not constitute criminal conduct. This was an astonishing ruling in view of the omission to act liability that the Kennedys' attorneys had feared. John Farrar, of course, disputes Boyle's contention that there was no evidence that air had remained in the car after it was submerged. 2 of us in the fire department saw air emanating. Remember, they saw bubbles coming up from what they later found would be the trunk. And that was the part of the car, we'll put the picture back up, but that was the part of the car that she had been in closest to the trunk. She was back in the rear footwell with her head pressed toward the ceiling, and then the trunk is right here. So it is possible to make some fairly scientific conjectures about whether or not there may have been an air bubble. Next on the stand, Farrar testified he had found the victim's head cocked back, face pressed up into the footwell. So she was like this, holding herself to the seat, hands holding herself in such a position such as she could avail herself of the last remaining air in the car. Fernandez cut Farrar short. "You don't know what was done," he said. Farrar was to describe exactly what you saw and not speculate on whether professional rescue efforts, if promptly made at the time of the accident, would have saved Mary Jo Kopechne's life. Boyle suggested a description of the car's length and weight would be helpful for him in making his report. After receiving specifications from a local Oldsmobile dealer, Richard McCarran dictated an affidavit to Donegan. In concluding the inquest, Boyle had gone over the evidence to make sure he had not omitted anything that might be available, and then find out if there was something I didn't obtain. But Boyle's self-congratulation was vainglorious. The inquest had been conducted in a haphazard manner. Gaping contradictions in testimony allowed to go unchallenged during the incomplete questioning of witnesses who were called in no particular order or sequence. No attempt had been made to confront one witness's testimony with another's regarding continuity or consistency. Skeptical as Boyle was about the testimony of the Boiler Room girls, he had confined himself to making ironic remarks about it from the bench. Yeah, he saw it. He did nothing to squash it by legal means. He just saw it and kind of wryly comments about it, but does nothing. Other relevant witnesses had not been called to testify. You'll remember Sylvia Malm and her daughter. They lived at Dyke House, right there by the accident. Her daughter had been reading under an open-faced window facing Dyke Bridge sometime between 11:15 and 11:45 on the night of the accident. She heard nothing. Denise did not bother to call other Dyke Road residents who left their lights on in their houses to challenge the senator's testimony that there were absolutely no lights in the area that I noticed. Foster Silva was not called to testify about the yelling, music, and general sounds of hell-raising that he had observed at the Lawrence cottage that had continued until 1:30 a.m., a report at variance with the duration and character of the party that was described by inquest witnesses. Denise had kept Flynn's investigation of license plates off the record. And Stan Moore and others, like the 3 registry inspectors who were prepared to give testimony that would have discredited Kennedy's version of the accident, were not called. Fernandez defended the inept character of the inquest. You've got to remember, this wasn't a trial. It was an informational process, hence no cross-examination. Boyle decided what got on the record and what didn't. Some purely hearsay, like Kennedy's beer with Jack Driscoll, was allowed. Other hearsay evidence was not. We were hidebound by that. Under Boyle's guidelines, you really couldn't question the testimony. It was just received. Denise is satisfied that they've put everything on the record that can be. He says, when we started, we had nothing. Now we have a hell of a lot more. But he declined to speculate on the possibility that criminal charges against Ted Kennedy would come out of the inquest. He could make no decision about prosecuting before Boyle filed that inquest report, but he thinks it's unlikely the grand jury would take action. He does say, should Boyle's report find negligence on the part of Senator Kennedy that had contributed to Mary Jo Kopechne's death, Denise would have no choice but to seek an indictment for manslaughter. Kennedy left Cape Cod immediately. I'm glad it's over, he told reporters at Washington National Airport, a short distance from the lobby where Bernie Flynn had disclosed all the inquest evidence to Jack Miller. I answered the questions to the best of my ability, Kennedy said. I am hopeful now of getting back to the business of the Senate. But the drama's denouement was yet to come. Judge Boyle asked to be relieved of court duties in order to devote himself to reviewing 763 pages of inquest testimony. On February 18th, which the inquest happened from January 5th to the 8th, so we're talking about 6 weeks later, on February 18th, a tightly sealed cardboard box containing the inquest transcript and report was carried from Edgartown to be locked in an office safe in Boston. The documents would be available to Denise, Attorney General Robert Quinn, and counsel for any person named in the report. Lawyers for other witnesses would be allowed to check their client's testimony for accuracy and submit corrections. Edward Hanafy's petition requesting review was promptly granted, and a week later, Hanafy was allowed to examine the inquest report, a step-by-step recapitulation of the known facts of the case based upon testimony that contained inconsistencies and contradictions too numerous for Boyle to enumerate. The report placed the time of the accident between 11:30 p.m. on July 18th and 1 a.m. on July 19th, straddling both Kennedy and Look's schedules of the accident. Under the statute, Boyle had to report the name of any person whose unlawful act or negligence appeared to have contributed to Mary Jo. Based upon inquest evidence, Boyle inferred that Kennedy and Kopechne did not intend to drive to the ferry slip, and that his turn onto Dyke Road had been intentional. That's honesty right there. Dyke Bridge constituted a traffic hazard, particularly at night, and must be approached with extreme caution, Boyle said. A speed of even 20 miles per hour, as Kennedy testified to, would be at least negligent and possibly reckless. If Kennedy knew of the hazard that lay ahead of him on Dyke Road, his operation of the car constituted criminal conduct. Since Kennedy was driven over Dyke Bridge twice on July 18th, Boyle believed it was probable he knew of the hazard. But for some reason not apparent from his testimony, he failed to exercise due care as he approached the bridge. I mean, my jaw dropped when I was reading this because I have not gone back to do the research before any of this, so I'm learning about what happened with the inquest right alongside you. And this is a clear description of the negligent driving that Ted Kennedy had done. I'm surprised to find it in the inquest. Boyle therefore found that there is probable cause to believe that Edward Kennedy operated his motor vehicle negligently, and that such operation appears to have contributed to the death of Mary Jo Kopechne. Having found probable cause, however, Boyle failed to exercise the statutory requirement to issue process for the arrest of the person charged in the report. By citing the law that required him to issue the warrant, and not doing so, Boyle was admitting that his action was unlawful. But whether he made the charge officially or not, the damage was done. Not only had he impugned fault to Kennedy's driving, but suggested that he and others had lied at the inquest, consolidating all public doubts and suspicions about the case in one damning and devastating conclusion. Kennedy's lawyers were stunned. We read the report in advance, McCarran recalled. If Boyle thought Senator Kennedy was guilty of a crime, we thought he should have bound the case over to the Superior Court. But McCarran was glad that he hadn't. The judge had left a narrow loophole, and perhaps it was large enough for Senator Kennedy to slip through. In guiding himself with regard to the proof required of the commission of an unlawful act, Boyle had applied the standard of probable guilt. Boyle was virtually inviting Denise to do something about it. Angered that the DA had required him to hold this inquest, he was now bouncing it back onto the shoulders of Denise. If anybody was going to bring charges against Ted, it was Denise. Denise was on vacation in Portugal. Denise told a local publication that the Chappaquiddick case had not been shelved. The judge is preparing his report, he said, and when I get back, the report will be presented to me. Our system is a rule of law, not a rule of men. What a charade. It is a rule of men. Men are making all sorts of things, making up new licenses, changing the times of things, ignoring evidence, disallowing evidence to be put into the inquest, not asking questions that ought to have been asked. It's entirely what we've seen play out in front of us is the rule of men, not the rule of law. So it's really proud and ridiculous that he would make this statement. Denise was going to get the chance to prove his words when he was ushered into Suffolk County Courthouse and shown the report. Son of a bitch, Denise muttered, stormed out of the building and refused to talk to reporters. Boyle had gone as far as he could go, but he fell short of an indictment. He could have, in his discretion, brought charges, but he didn't. What he said, Fernandez explained, was, in effect, yes, there's some evidence of negligence here, but not enough to bring a charge. How much negligence was required to become legally criminal was a line very difficult to draw. Clearly, Denise was not prepared to draw that line. His experience in investigating the case had been sobering. Prodded by the press to enter the case, once he did so, he had been subjected to ridicule and accusations of seeking to advance his own career. In seeking answers to the mysteries, he had encountered a judicial stone wall. Fed up with being the scapegoat, Denise complained others in appropriate power avoided everything. Denise had run out of options. There was no alternative now except to prosecute Ted Kennedy on the basis of the inquest evidence, as Boyle was challenging him to do, or fail to bring charges and be accused of dereliction of duty. With Boyle's report a ticking time bomb, ready to explode when it was made public, Denise made no decision at all. But Jimmy Smith, who's the Kennedy man who's in the DA's office, right? He's kind of like a subversive, but nobody knows it. They've kind of been able to hide his identity and connection to former Kennedy campaigns. And so he is an observer who they've kind of kept out of the case, but who's watching the whole thing and discerning what's happening with some Kennedy insight. He notes that Denise was clearly unwilling to prosecute the case. Denise didn't want to go down as the guy who put the bullet in Teddy Kennedy. He wanted to save him. Chapter 52 observations are these. Huck Look's testimony is that there was a dark car with an L7 license plate. Flynn calls all L7 owners with Oldsmobile-type vehicles, and he proved that the car that Huck Look had seen had been Ted Kennedy's car. But this evidence is not included in the inquest evidence, so it goes unnoted. Registry inspector admits that Ted's license was produced after the fact. Boyle says there was no evidence of any error in the car. Farrar's testimony, therefore, is undercut by this previous statement and kind of direction given by the judge. Boyle notes the inconsistencies among the boiler room girls, but he doesn't confront it to clear up the details. Many first-hand witnesses were not called to the inquest. For example, the neighbors to the cottage who observed the nature of the party and the Dyke House residents, as well as some of the other people who had seen Ted Kennedy the night before. Denise is satisfied. Ted Kennedy leaves and returns to D.C., and Boyle finds probable cause, but does not order an investigation. Now it's in the hands of Denise. Okay, the last chapter that we're going to get to today is 53, and I'm really excited because this means we're getting through 4 chapters today, and that leaves 54, 55, 56, 57 for our last episode. So I think we're going to be in good shape. Let's get into chapter 53. That the inquest documents had not yet been made public immediately suggested to grand jury foreman Leslie Leland that the report had been unfavorable to Senator Kennedy. Leland confers informally with the members of the grand jury, and questions about Kennedy's explanation remained. Jurors suspected that the senator had devoted a considerable portion of his 9-hour delay to try to grope for some way of escaping involvement. One juror said, "Most of us felt Kennedy was morally responsible for the death of that girl. We talked about bringing in Kennedy and some of the girls present at the cookout." On March 17th at his drugstore in Vineyard Haven, Leland composed a letter to the Chief Justice Joseph Taro of the Superior Court, asking that a grand jury be called out of recess to consider the Kennedy accident. He felt that they had a duty to come up with answers that have been long overdue and to try to close the case once and for all. everyone feels that a great injustice has been done to the democratic process and that there's been a whitewash, a cover-up, and that things have been swept under the rug. A great deal of time has passed since the girl died, and it's time the public found out what happened.
Speaks for all of us.
Leland directs his letter to the court in the proper way through the DA's office. He wanted to keep it an Edgartown case, Jimmy Smith notes. That's the island mentality. We're going to keep it here. We're going to deal with it here. Denise receives an advisory opinion on March 24th that he could convene the grand jury into special session at any time. Leland hoped that the inquest report would be made available, and if it wasn't, so he thinks the grand jury should have access to the inquest report. But if it wasn't, the grand jury could subpoena everyone who attended the party at Chappaquiddick and commence their own investigation from scratch. We want to finalize this matter once and for all, he says. That Denise had not taken the initiative in seeking further prosecution had indicated to the defense lawyer, Dick McCarran, that no further charges against Senator Kennedy were justified. But there wasn't anything McCarran could do to head off a new investigation if the grand jurors decided to do that. He gets the grand jury list and commences a rundown on members, trying to, I guess, reach out to them and feel them out, maybe do some preemptive fixing. It's not elaborated here, but that's what I'm wondering about, is commence a rundown on members. Senator Kennedy faced the most serious liability from the accident since Denise had asked for the inquest. What his attorneys feared was an indictment for manslaughter emanating from the grand jury when it assembled on April 6th. But judicial good fortune continued for favoring Ted Kennedy. Assigned by Chief Justice Taro as custodian of impounded inquest documents was Judge Wilfred Packett. A portly man with a reputation for indulging his disagreeable temper from the bench, Packett was a curious choice. He had been a former member of the Democratic State Committee, and he was, of all jurists assigned to hear aspects of the Chappaquiddick case, the one person you could call a Kennedy file. So they put a guy who absolutely adores the Kennedys as the one who's hearing the case. In addition, Packett was a former client of Edward Hannafy, that's Ted Kennedy's lawyer. For over an hour, he harangued the jurors against being too zealous, stressing the need for an unbiased investigation. You must bear in mind that you will not be trying this case. Your function is to indict those people who you believe committed a crime. You decide an indictment strictly on the evidence submitted to you. More importantly, Packett didn't think it was legal for the jurors to see the inquest documents, and he refused to permit them to examine the transcript. The grand jury could have appealed to the Supreme Court for the release of these documents, or they could have started their own investigation, but they were led to believe that they could not subpoena Senator Kennedy or any witnesses who had testified at the inquest. So they are prohibited from asking any questions of the people who had already come to the inquest, and they're prohibited from reading the report of the inquest. This is a critical error in their interpretation of Packett's instructions. Denise did nothing to disabuse them of their misinformed perspective. Jurors could only summon witnesses who had new information, he told them. So he's just playing right into it, which is crazy. By law, Denise was required to present evidence and avoid expressing an opinion as to whether the indictment should be handed down, but he deliberately steered the jury away from the pursuit of charges against Senator Kennedy. He suggested there was nothing in the inquest record upon which to base an indictment. Despite having read the report himself, he led jurors to believe that Boyle had found no wrongdoing. Leland went personally into the judge's chambers to plead again for a copy of the inquest documents, to no avail. Packett refused. As its first witness, the jury called Stephen Gentle, the owner of that Katama Air Park. Remember, there was a rumor that the plane had left his airfield during the early hours of July 19th. He denied that happened. They heard from an Edgartown resident who told them he had overheard an argument early in the morning, but nobody could identify the person. Having sent someone from his office to mingle with reporters to find who the grand jury was calling to testify, McCarran learned to his delight that these were witnesses who didn't know anything about the case. Though reluctant to stop there, the grand jury had no choice. It was very discouraging, one juror said. We had no cooperation, so we felt as though we might as well go home. At 10:55, the grand jury filed into the courtroom. Leland announced he had no presentations to make, and the jurors were excused from further deliberations. It was made quite clear that I can't talk to anyone, a dejected Leland told reporters. Denise was hardly able to contain his relief at the end of this particular investigation into the death of Mary Jo Kopechne. He said, "The case is closed." Later, Denise said, "The grand jury was without purpose. They were on a wild goose chase. I challenged them to come up with more evidence, more witnesses, but they couldn't produce anything." The wild goose chase had Edmund Denise as its guide. They are going on a wild goose chase because of him. He has failed to give them the information that they need and even contributed in their misapprehension of the rules that they were operating under. He later admitted, "There's no question in my mind that the grand jury would have indicted Ted Kennedy for involuntary manslaughter if I had given them the case. That Denise had not chosen to do so was an exercise of prosecutorial privilege," Armand Fernandez said later. Packett's refusal to allow the inquest documents had been crucial in keeping the case out of the grand jury's hands. Gargan agrees that the ruling was a questionable call, and Packett refuses to discuss the case. He tells reporters, "To hell with you, I don't have to talk to you." Senator Kennedy, of course, was happy with the findings of the grand jury, but one juror bristled at his statement, "There were no findings. We weren't allowed to make any." The senator, ironically, is now anxious for the inquest transcript to be released to eliminate any suspicion in the case. But the report was bound to have a devastating effect on his career. There was, however, a trade-off worth the price. According to Supreme Court rulings, the release of inquest documents would forever prevent Ted Kennedy from being prosecuted on any charges dealing with the death of Mary Jo Kopechne. Whether he had been found probably guilty of manslaughter and suggested that he lied at the inquest didn't really matter. Legally, Kennedy would not be allowed to be touched. I don't understand that, I guess because of double jeopardy and the fact that they had made sure that the constitutional rights were protected, that if anything came out publicly, there wouldn't be another case, I guess is what they're arguing. But it's crazy. So he really wants this to be released, even if it's damning, so that then he can just move on and not have to worry about any other investigations or court cases in the future. On April 29th, more than 50 reporters crowded into Suffolk County Superior Court in Boston for the release of the bulky documents. What reporters read staggered them, detonating another explosion of controversy about the case. That Senator Kennedy had not spoken the truth was the only finding a jurist of integrity could make, charged the New Bedford Standard Times. Grand jury foreman Leland was trying to digest what I'd heard about the inquest documents. He hadn't had a chance to read them yet. Denise had sat through the grand jury session knowing what was in the transcript and report without letting us know, he said. Things might have been different if the grand jury had seen the documents, but we couldn't get our hands on it. One grand juror, Teresa Morse, observed, "A bigger bunch of dumbbells you'd never hope to find. I most certainly include myself. We were dupes and boobs and let ourselves be manipulated. Nobody ever briefed us properly about what we could do. We were a powerful body made impotent by Mr. Denise." Well, Chappaquiddick ended as it began, in mystery, with many questions unanswered both by Senator Kennedy and by authorities, the Standard Times said. This was a classic example of how the ends of justice can be frustrated. The Boston Record-American said, "The case may be closed in the eyes of the law, but it leaves Senator Kennedy under a cloud. And though that may diminish in time, it will cast a shadow on his future." In a statement issued from his office on the day that inquest documents were made public, Senator Kennedy announced, "The facts of this incident are now fully public. For myself, I plan no further statement on this tragic matter. Both our families have suffered enough from public utterances and speculations." Attorney General Robert Quinn shut down speculation about any future action, No criminal action is likely against Senator Kennedy. The legal aspects are over, he said. Politically, it remains to be seen. Our Chapter 53 observations are: the grand jury foreman, Leslie Leland, is eager, and he requests the handoff to the grand jury. Leland speaks quite sensibly in regard to the whole thing. He seems to be seeing clear-eyed. But between the lawyers, the judge, and DA Edmund Denise, the grand jury doesn't understand their role and powers, isn't given the inquest documents, isn't allowed to subpoena Ted Kennedy or the Boiler Room girls. They believed that they could not. And so therefore they have virtually no witnesses and can make no new findings. Ted Kennedy is happy. The DA is happy. The media is floored. And the grand jurists are alarmed. Okay, you guys, I'm feeling so happy about this. Look, we have it's still not nothing. We've got 40 pages we have to get through next time, but I'm so excited. Then we are done. This is all end material. So let me know in the comments what you understood, took away, and noticed after today's discussion. I feel like my perspective on the accident is crystallizing, and I hope yours is too. Let me know in the comments. I want to talk to you about it. And next time, I do plan to not only wrap up the book, but share with you where I'm at in regard to what I believe happened on Chappaquiddick the night of the accident. I hope you have a great day, and I hope you're enjoying this read. I want to invite you to join me for the other things happening, including Tina Brown's The Palace Papers. I'm really thankful for you and for the conversations we get to have together. Bye.